Stand, please. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-5217, Mark Jordan, appellant, versus Federal Bureau of Prisons, and Colette Peters, Director, U.S. Bureau of Prisons. Ms. Foley, amicus curiae for the appellant, Ms. Patterson for the appellees.
Ms. Foley, good morning.
Good morning, Your Honors. May it please the court. I'm court-appointed amicus for appellant Mr. Mark Jordan, and I'd like to reserve 4 minutes for rebuttal, please. Sanctions C through M are contrary to law, and Mr. Jordan has standing to challenge them. Due to the minuteness of BOP's rules and its close oversight of Mr. Jordan, he is at substantial risk of incurring the sanctions of which he complains during the 23 remaining years of his incarceration, as his lengthy disciplinary history shows. He also suffers.
Let me ask you about his remaining sentence, because according to the record anyway, there have been 3.5 years almost that there have been no sanction.
I disagree with that, Your Honor. The record below only goes up to the time of his complaint in 2020. And in the 5 years prior to the filing of his complaint, he was found to have committed at least 9 prohibited acts, and he incurred at least 18 separate sanctions for those acts.
How about 20?
Of which, excuse me?
How about 2020 forward? That's what I'm talking about.
The administrative record below is not pellucid on that point. There's nothing in the record about that. And so I think this court has to base its standing holding on what is in the record. Alternatively, I suppose the court could remand for further factual development with respect to Mr. Jordan's standing. But on the record before the court, I think it's very clear that Mr. Jordan is at imminent risk of incurring additional sanctions in light of his lengthy disciplinary history, and in light
okay, let me just say this. I'm not saying you were required to do this. Did you think about updating the sanctions record?
So I was not I was not amicus or representing Mr. Jordan's below. I came in on appeal, and so I can't speak to whether or not that was considered.
Well, you could have. Are you saying you couldn't have done it since you've been appointed?
I suppose I might have. I don't think it was.
All right.
I'm sorry.
Go ahead.
So I think it's clear that on the basis of the record that is before the court, and the record that was accrued up to the filing of Mr. Jordan's complaint, I think it's clear that he does have standing on the basis of imminent injury. And this is due not just to Mr. Jordan's lengthy disciplinary history, but due to BOP's close oversight of inmates like Mr. Jordan, and the minuteness of its rules of conduct, which prohibit quotidian conduct like insolence, swearing, OSHA violations, and untidiness. And on those bases, I think it's very clear that the court should find standing. The court could also find standing on the basis of ongoing injury.
Can we go back to the future injury, counsel? What, in your view, is the right way to think about the time horizon for that? If we're asking, is it sufficiently likely he'll be subject to one of these sanctions again? Are we talking a few years? I think at one point in your brief, you say we should look at the whole 24 years remaining in his sentence, and it seems like that can't be right.
Well, I think in NB ex rel Peacock, this court spoke of the likelihood of injury within a fixed period of time. I think that period of time can be relatively long. In NB ex rel Peacock, I believe it was a year to 18 months. And in Lee versus Weissman, the Supreme Court found prospective relief standing on the basis of likelihood of injury, in the likelihood that a prayer would be said at a high school graduation 4 years in the future. So I think the important thing is that the time period be fixed. But if the court were uncomfortable with looking at the 23 remaining years of Mr. Jordan's sentence, it could shorten that period to a shorter period, such as the 4 years at issue in Lee versus Weissman, or even 18 months. I think it's still virtually certain that Mr. Jordan will incur additional sanctions within that fixed period of time.
Okay, and then I think Judge Rogers, I think you're muted. Well, I'll just ask, I was going to ask, it seems to me your argument for standing is pretty straightforward in one respect. You're saying in the 5 years before the complaint, he was subject to this kind of discipline 9 times, depending on how you count. And so it's likely he'll be subject to it again. But the government, as I don't know if you've acknowledged yet, we have all of these cases saying we generally expect litigants to follow the rules. And just wondering what your response to that line of cases is.
Sure. Well, I think the assumption underlying the presumption of lawful conduct inheres, at least in part, in the permissibility of quotidian conduct, and also in the fact that ordinary citizens going through their lives are not under constant supervision by law enforcement officers, and neither of those assumptions is true here. As I mentioned, BOP's rules of conduct do prohibit quotidian conduct. And inmates like Mr. Jordan are under constant surveillance. And I just want to note that Mr. Jordan, rather than 9 separate sanctions, he incurred 18 separate sanctions in the 5 years prior to the filing of his complaint. And of those, 15 were of the type he challenges here.
Let me ask you about remoteness. He doesn't challenge the rules, and unlike Ramen or whatever it is from the 70s, it's not an informational injury. Isn't it even more remote if he's not challenging the rules that he's going to be sanctioned for rules that he does not challenge?
I don't think so. First of all, I think that in Raymer versus Saxby, the court didn't simply rely on the informational injury, but rather on the inmate's subjection to the rules in general. I think that's clear from the fact that the court found that the inmates had standing not just to pursue their claim for the BOP's failure to publish the rules, but in addition for the notice and comment claim. And I think that perhaps with the typical inmate whose disciplinary history weren't so lengthy and who didn't demonstrate such a proclivity to violate BOP's rules, that there might not be ongoing injury. But Mr. Jordan's disciplinary history shows that he is extremely likely to violate these rules, and so I don't think it's remote at all to think that BOP is going to impose these sanctions on him, as it has done repeatedly in the past.
All right, so you're basing that on the longevity. At least that's what I hear you saying. So how do we prevent every long-serving prisoner from following this precedent if we rule in your favor?
I think that an inmate, in order to have standing and in order to stand in the same shoes as Mr. Jordan, would have to have a similarly lengthy disciplinary history. And I don't think that the court should be concerned at all about inmates offending in order to put themselves in the position of having standing, because the sanctions they would be risking are pretty serious. I don't think that an inmate would risk months in solitary confinement or even loss of the few privileges that federal inmates do have in order to manufacture standing. I'd like to move on to the merits if the court has no further questions about standing. I think that American Bus controls the outcome here. In American Bus, this court said that Congress could not have spoken more clearly than it did in Section 558B of the APA, and that express statutory authorization is required for sanctions. Now, BOP attempts to cabin American Bus to statutes that expressly state that the particular sanctions are the only ones that an agency may mete out, but that reasoning is completely absent from the portion of the opinion addressed to Section 558B. Applying American Bus here, BOP is limited to the particular sanctions that Congress has provided for by statute. Those are the revocation of good conduct time, FSA incentives, and for eligible inmates, statutory good time and parole. I think Congress could certainly have granted BOP broad sanctioning authority. It did so, for example, to the Attorney General in 18 USC Section 3600A, where it gave the Attorney General the power to promulgate regulations, quote, including appropriate disciplinary sanctions. But it didn't do so here, and BOP is therefore limited to the sanctions that Congress did provide. I also think
Counsel, it seems to me that the sort of simple point on the other side of the statutory issue is that your position would mean that when the statute says BOP may provide for discipline, that means it gets to set out all sorts of rules for conduct, but can't establish any way of enforcing those rules. Is that, mistaken as an implication of what your argument is?
Well, I don't think here that BOP has its hands tied as to enforcing those rules. It simply means that Congress, it needs to use the sanctions that Congress has specifically provided for.
Right. So it does mean that this statute alone gives them no authority to enforce the rules that they're allowed to set out.
I think that's the necessary implication of my position. Yes.
Okay.
And BOP argues that the word discipline carries an awful lot of weight, and that discipline gives it the authority to mete out sanctions. But I think the best way to think about the word discipline is that it refers to good order. Congress empowered BOP to, as Your Honor mentioned, provide for inmate discipline by issuing rules of conduct governing inmates. But under American Bus, BOP still needed express statutory authorization for sanctions. Now, Congress provided that authorization with respect to specific sanctions, but it didn't speak generally in the way it has elsewhere. And I think if the general command, a general command that doesn't mention the power to sanction at all, like discipline or enforce, is all that's necessary, then it's difficult to see what work Section 558B's as authorized by law clause is doing. And I think it's also difficult to draw a line between disciplining and enforcing, or ensuring and protecting, such that it's hard to think of an agency that couldn't plausibly lay claim to the ability to craft and impose sanctions. Agencies are always instructed by Congress to do something, and under Section 558B, they can't just decide to use sanctions to do it. Congress has to have provided them with sanctioning power. I'd also point out that in common parlance, a word like enforce carries at least as much implication of sanctioning authority as does discipline. If I tell my child that I'm going to enforce the curfew, then he understands that I'm going to punish him if he violates it. And Black's Law Dictionary indeed defines enforce to include to compel obedience to. And to me, that carries the implication of sanctioning power at least as much as discipline does. But this court said in American Bus Association that Congress couldn't have spoken more clearly in requiring more. I see that I'm eating into my rebuttal time. I'm happy to answer more of the court's questions, or to yield to my friend.
Do you have any questions? Right now, I can't hear you. Is your sound on? You hear me?
No, but I think she's all set with no further questions. Oh,
Madam Clerk.
Are you able to unmute her?
Judge Rogers, you need to check your sound, Judge Rogers.
Sorry, but the system is not working, Judge.
Okay, we got you now. No questions then? Okay, all right, we'll give you 2 point. We'll wait. When did she stop arguing?
3 minutes.
Yeah, okay, you've got 3 minutes left.
Thank you.
Ms. Patterson, good morning.
May it please the court, Melissa Patterson for the Federal Bureau of Prisons. The appellant and the amicus both asked this court to adopt a really sweeping theory on which, when Congress gave the BOP the authority to provide for discipline within federal prisons, it meant to only create rules, but not to enforce them. We urge the court to decline to adopt that really extraordinary reading of BOP's authorities on one of either 2 grounds. First, that Mr. Jordan has not carried his burden of establishing standing. We recognize that Mr. Jordan is a pro se litigant entitled to a liberal construction of his pleadings. We also recognize that past injury can bear on the question of the ability to suffer a future injury. But even with those 2 principles in mind, we don't think Mr. Jordan has said enough here to establish the type of injury that would justify the purely prospective relief that he has sought throughout this litigation. Second, even assuming Mr. Jordan has standing, we think this court should simply reject his position on the merits. We think they hang their hat on this very narrow understanding of the word discipline that has no basis in the ordinary meaning of that word, either in 1930, when Congress first gave BOP this authority, or today. It has no bearing, no relationship to the way that the statute has always been implemented openly by BOP in ensuring discipline and order within its facilities, which is, of course, the Supreme Court has said, the central object of prison administration. And it would have the really extraordinary consequence that it would mean that Congress has never given, either in 1930 or today, BOP any authority to sanction the thousands of prisoners in BOP facilities who are serving life sentences and therefore are not eligible for either the parole recommendation or the good time credits that appellant argues are the sole sanction that is available for BOP to punish prisoners who break prison rules.
So on the merits, not saying I do agree with that argument, but it seems as though your argument is essentially the statute is unambiguously clear in providing this authority. And if we do agree with that, is it your position that we wouldn't even need to address the constitutional avoidance non-delegation argument because the statute is unambiguous? Is that an argument that you're making?
I think that's, yes, Your Honor. I think that discipline was unambiguously understood to mean the authority not only to create rules, but also to penalize those who break them within prison facilities. I think that was that was clear in 1930. That's been clear throughout the 95-year history of the BOP. And I think it's, certainly has far more than an intelligible principle, obviating the need for this court to get into any of the delegation arguments. I want to note that the invocation of major questions here is particularly extraordinary since it's amicus and appellant who are we're not seeking to expand any authority based on an newly discovered power. They're seeking to retract a long-held and very common sense implementation of prison administration authority, contrary to the entire history of the statute. So I think that the short answer to your question is yes, that this is clear and we are operating within the authority Congress has provided us.
Do you know whether the head of the Bureau of Prisons or through the Attorney General submits the code that corrections uses in the Bureau of Prison? It's not a formal submission, but it is a filing, as it were, with the Appropriations Committee. Do you know if that happens?
I don't know exactly what happens in the appropriations process, Your Honor, but I do want to note that the code, the rules, and the sanctions imposed for specific types of rules are very clearly set out in a notice and comment regulation. BOP, of course, had long provided for discipline for rules and penalties within its facilities, but in 1977, it undertook a rulemaking. It put out an NPRM. In 1982, it issued a final rule that sets out the various offenses, possession of a hazardous tool, everything from, failing to follow orders to these more serious offenses, like one of the ones Mr. Jordan created, such as murdering a prisoner in a BOP facility. So I think there's no question that BOP has been very transparent with the public, with Congress, with prisoners about the rules the inmates are expected to follow and the consequences that can follow if they break those rules.
I had a few questions about standing. So you said that more should have been expected of him. And I just want to understand what exactly else you think he should have done. And I think just to tee that up, it seems to me that in an ordinary case, his complaint essentially says, we've got 9 instances of the challenged harm in the past 5 years, maybe more depending on how you count, but a lot in the past 5 years. And he's going to be subject to this same regime going forward. And so it's sufficiently likely that he'll be subject to it at least once more in, say, the ensuing few years. Why isn't that sort of the straightforward argument for standing here?
I think because there are sort of 2 levels of uncertainty between the past injury and the future harm that Mr. Jordan is foreseeing here. And the first level is particularly problematic for him. And that is the assumption that he will engage in the type of conduct that could trigger the disciplinary sanctions in the first place. And I think that the basic pitch that Amicus and Mr. Jordan have presented here is that precept simply shouldn't apply in prisons because of the control that BOP has over inmates. I want to note that the Third and the Seventh Circuits have rejected that sort of approach. I want to note that the Supreme Court in Lewis v. Casey, I think, it hypothesized a prisoner who might think that the medical facilities at an inmate are constitutionally inadequate. And it made very clear, you don't have standing to challenge the contours of the infirmary if you're healthy. You have to show that the constitutional infirmity in this institution is actually going to injure you.
But isn't this like somebody who's been sick 9 times in the past 5 years?
And I
And
think,
there's no reason to think he's going to get any healthier?
well, I think that last part is what's missing here. I think if an inmate said, I have been sick 9 times in the past year, and I have a chronic condition that makes it very likely and non-speculative that I'm going to be in the infirmary in the future, notably absent from any of Mr. Jordan's either filings in district court or even in his filings to this court, and he has filed 3 briefs here, is any sort of statement of, he doesn't identify any rule that he intends to break. He doesn't even, and this goes to the ongoing injury, he doesn't even say my day-to-day conduct has changed as a result of this sanction.
If we focus on the likelihood of future injury, it seems like, are you saying if his complaint said something like, I've gotten all of these sanctions in the past, and despite my best efforts, it's going to be reasonably likely that I'll be subject to at least one of them in the next few years? I mean, is that what you expect him to have said in the complaint?
I think we would be closer. Now, of course, this court has said you can't just toss in a sort of undifferentiated, and I will be harmed in the future. So I think the court would rightly expect a few more specifics. I think our point here is that we don't have anything in any of the filings here to suggest that Mr. Jordan is claiming an injury that's any different than any other prisoner in BOP facilities, all 150,000, at least anyone who has previously incurred a sanction. And I do want to note the second level of uncertainty here is Mr. Jordan doesn't say all sanctions are unlawful. So the second level of uncertainty,
Just 90% of them?
just 90% of them, is that he would be not only in the future engage in misconduct that would trigger the application of these sanctions, that the disciplinary hearing officer would choose one of the sanctions that he contends is unlawful.
So it seems like, and this might be right, that this argument really hinges on this assumption that has been applied in the context of validly enacted criminal laws that people won't, again, violate a criminal law. Because without that, it seems as though this looks a lot like a case like Peacock, right? You're going to have an ongoing engagement with this regime, and your past experience shows that sometimes the challenged harm exists. And so it's reasonable to infer it's going to happen again. And really the key here is that, unlike with Medicaid applications, you're saying we just shouldn't countenance an assumption that he's going to violate these rules unless he specifically says so.
I think that's right, but I'm not suggesting that's the only way an inmate could challenge a BOP policy. If an inmate can articulate a way that on a day-to-day basis, a BOP rule or regulation is altering his conduct, that may well suffice for an ongoing injury. If Mr. Jordan had declined to pay his fine and simply suffered an ongoing encumbrance of his account, I think that would count as an ongoing injury. Unlike a scenario like the Peacock, where I think we were talking about prescription refills, and there were specific allegations of I'm experiencing ongoing denials of my prescription refills. I think that plaintiff introduced statistics showing the likelihood that any individual refill prescription would be denied. We had a lot more of the type of details on which the court could base its prediction that an injury would indeed be substantially prominent, imminent, certainly impending, there's a substantial risk of it, whichever rubric the court picks, that you had more on which to base that prediction.
Well, Peacock went way beyond the plaintiff. I mean, it talked about all the Medicaid, or a lot of the Medicaid patients in DC. Isn't that right?
I'm not sure, Your Honor. It certainly started at standing analysis by looking at the specific pleadings. And again, there were statistics about the likelihood of any one individual application getting the type of denial they alleged for it was unlawful. I don't want to overplay our standing hand here. Again, we do acknowledge that Mr. Jordan is entitled to some liberal construction. It's just, it has to be a construction of pleadings he's actually made. And we don't have any of the pleadings of either ongoing injury, that these, unlike the case in Raymer v. Saxby, where the alleged unlawful action there, the failure to publish rules, the court said it affected a day-to-day injury because inmates were unable day-to-day to conform their conduct to the rules that they didn't know the contents of. If Mr. Jordan were challenging any of the substantive rules that say you have to, I don't know if it actually says you have to make your bed, but any of the rules against untidiness or insolence or violence, if he were saying any of those were beyond the BOP statutory authority, I think it'd be pretty easy to find standing on the basis of what he said so far. But he's not. He's only challenging the follow-on. If I break one of those unchallenged rules, will I be disciplined with a type of sanction that I say is unlawful and not one of the sanctions I think is lawful?
Let me ask you about, according to the record, what is the last time he was sanctioned?
I believe it's 2019.
Right. And he's filed 3 briefs. Has he made any allusion whatsoever to having been sanctioned since 2019?
I do not believe so. I think he cites some of his litigation in other circuits from 2023 that refers to sort of a long disciplinary history, but nothing in either his filing, and I don't know if that separate court case refers to any misconduct. As far as I know, based on the record before us, the last imposition of discipline was in 2019.
Counsel, don't we assess standing on a motion to dismiss based on the time the suit was initiated and based on what's in the complaint?
I believe so, Your Honor. I think there's been a suggestion that the court should remand to sort of permit Mr. Jordan a chance to amplify his filings. We're not disputing that that's within the court's power, but we think given the long history of this litigation, the fact that Mr. Jordan has been filing briefs, and as far as we can tell, there are none of, he doesn't say, if only I had known, I would have alleged X ongoing injury, or I would have done more to shore up my risk of future harm than anything he said so far. We think the more appropriate disposition would simply be to dismiss for lack of standing. If Mr. Jordan has since formed those intent or has suffered more recent disciplinary violations that he thinks gives him a basis to seek this type of relief, we think the more appropriate route would be to allow him to initiate a new suit on that basis.
Judge Rogers, do you have any questions?
No, thank you.
Thank you. We ask this court to reverse with remand with instructions to dismiss for lack of jurisdiction, or in the alternative, if it concludes Mr. Jordan has standing, to simply affirm.
Thank you. Ms. Foley, you have 3 minutes.
Thank you. So I'd like to address standing and the non-delegation doctrine, which my friend mentioned, which I didn't really cover in my opening. So on standing, this is a pro se complaint, and the sheer number of past violations certainly does distinguish Mr. Jordan from every other inmate. Presumably he was trying not to incur sanctions back then, because he was the sanctions he could have incurred, as I mentioned before, could deprive him of the few privileges that federal inmates have, or even land him in solitary confinement. I think Judge Garcia made an excellent point that standing is assessed on the basis of the time of filing. And I think it's important to note too that this court in NB ex rel Peacock noted that none of the plaintiffs there expressly alleged standing. Those plaintiffs were counseled, but the court read their allegations in their favor and drew reasonable inferences therefrom. And in terms of statistics, I think Mr. Jordan has presented a compelling case for standing on the basis of imminent injury on the basis of his past offenses. With respect to the merits, I think that reading the statute in the way that BOP asks would violate the non-delegation doctrine. And I would point this court to Gundy. In Gundy, a majority of the Supreme Court, that is the four justice plurality and the three justice dissent, agreed that if the statute there at issue gave the Attorney General, who undisputedly has kind of oversight over the criminal law, if it gave him the power to write his own criminal code by specifying whether sex offender registration requirements would apply to a class of offenders, then the non-delegation doctrine would be implicated. The plurality therefore read the statute narrowly to grant the Attorney General the power only to specify when those registration requirements would apply. Here, BOP claims the power not just to write its own quasi-criminal code, but also to craft the vast majority of the punishments for violation of that code. That's a breathtaking assertion of authority, and BOP purports to locate it entirely in the word discipline, or perhaps in the word discipline paired with its authority to manage and regulate the federal prisons. That's simply not enough congressional guidance for the exercise of such awesome power. And this court and the Supreme Court have both noted that the more congressional power is granted, the more precise must be the directions for its use. If the court has no more questions in my few remaining seconds, I'd just like to note that a plaintiff's burden to establish standing at the pleading stage is not onerous, and Mr. Jordan's pleading is more than adequate. The court should therefore hold that he does have standing. If the court were to find that Mr. Jordan lacks standing, then certainly this case should be remanded so that Mr. Jordan can replead. On the merits, the court should follow American Bus and reverse and remand for further proceedings.
All right, Ms. Foley, you were appointed by the court, and we thank you for your very able assistance.
Case number 23-1045 et al. Huntsman Petrochemical LLC petitioner versus Environmental Protection Agency. Mr. Lazzaretti for the petitioners, Ms. Chen for the respondent.
All right, Mr. Lazzaretti, good morning.
Morning.
Yeah.
May it please the court. My name is John Lazzaretti. I'm here today representing Huntsman Petrochemical, American Chemistry Council, and Louisiana Chemical Association. I'd like to request 4 minutes for rebuttal. Thank you. Your Honors, we're here today challenging EPA's ethylene oxide risk value for the miscellaneous organics NESHAP, or MON rule. The reason the parties put this issue first is that it is dispositive. If the risk value is wrong, the MON rule is wrong. And here the risk value is wrong for several reasons. EPA did not follow the Clean Air Act, it did not follow the National Academy of Sciences recommendations, and it did not follow its own guidance. EPA ignored significant flaws raised in public comments, and rather than base its risk value on sound science, it boiled 17,000 data points into 5 categories, graphed them, and eyeballed the graph. That is not what the Clean Air Act requires, and it resulted in an arbitrary and capricious rule. I'd like to start by addressing 2 statutory violations arising from the MON rule. First, EPA gave an impermissible preference to its IRIS value, or the Integrated Risk Information System value. And second, it ignored the National Academy of Sciences recommendation. On the first issue, the Clean Air Act requires EPA to consider all credible and relevant toxicity information in setting risk values. It cannot just use the latest entry from its IRIS database. This is what Congress adopted when it incorporated the benzene NESHAP into the Clean Air Act in 7412 F2, and it is what EPA told Congress it would do in conducting residual risk assessments in its report to Congress in 1999. EPA does not argue otherwise in its briefs. The EPA deviated from this required approach in the Mon rule. The final risk value relies exclusively on the IRIS value. EPA put IRIS on a pedestal and made it the default value in the rule itself.
So I agree it would be a problem if there were studies you had pointed to that EPA disregarded entirely, which seems to be the type of argument you're making. But it seems to me that for each of the issues you raised, EPA at least discussed it in some way. And so what we're really doing is fighting over the adequacy of EPA's explanation for why it didn't modify the IRIS value based on any of these studies. Is that fair? You might still be right that they didn't give adequate explanations, but is that what's going on?
Well, Your Honor, first to parse, there's a statutory issue that EPA had a preference for IRIS, and through that did not view other evidence in the right light. Under 7412, that would be a statutory violation separate of whether they even addressed the issues. And we've also identified a number of issues that they didn't address. And I do want to distinguish, because you used the word studies. And certainly the agency has pointed to topics that they discussed that are similar to the issues. So if we raise a concern about smoker data, the fact that the IRIS value predicts a linkage between smoking and lymphoid cancer that simply doesn't exist. They've addressed another topic on smoking. So they may have addressed the study, or they mentioned the study, but they haven't addressed the issues that we were raising. And so that disconnect between the reality checks we've identified and the response that they've made is problematic, even if they had the correct standard under 7412.
Well, I think maybe the smoker studies are a useful example, right? Because you pointed to my understanding is you pointed to specific studies, and EPA discusses those studies on a specific page of the response at the reconsideration stage. And it explains, maybe not in the most articulate way, that there were, two problems with those studies. They ignored confounding factors, and they used this hemoglobin marker that EPA doesn't view as validated. And so don't you need to persuade us that those explanations are irrational or arbitrary? Or is there a different point you're making?
Irrational or non-responsive, Your Honor. So for example, on the first one, our point is that there is ethylene oxide in cigarette smoke. There's a good deal of it. There's so much that if the IRIS value were correct, there would be a roughly 1 in 10 risk of smokers developing lymphoid cancer. So there would be a strong signal of a risk of lymphoid cancer. It would be linked. We have decades of research from the CDC that shows no linkage between smoking and lymphoid cancer. Now their response is, well, you haven't validated the data, so we don't know exactly what the amount of lymphoid cancer should be when you smoke. But the point is, it doesn't matter. If it's 1 or 2, if it's supposed to be 10 and we're not seeing that, that's the reality check that they were missing with the IRIS value.
Well, I don't want to spend all day on these studies, but assume, I'm just a judge, assume the hemoglobin marker is the wrong baseline to measure whether ethylene oxide is causing cancer. If they're right about that, what value does these studies finding no correlation, aren't they basically irrelevant?
Your Honor, they're not saying that those are, in fact, they use those adducts as well for determining a correlation. So what they're not saying is that it's an unreliable adduct in general. They're only saying that that relationship, while well established at higher concentrations, hasn't been scientifically validated for lower concentrations. Now that's a little untrue as well, as we point, the data was available for EPA to do that validation. They simply didn't do it. But even if the agency wants to raise, perhaps the number would be slightly different. What we're talking about here is orders of magnitude different. So it's simply not addressing the issue with respect to whether the IRIS value was reasonable to use for setting a risk value for the monitoring. And again, that's getting to a technical issue where first EPA has to show that it is authorized to use the IRIS value the way that it has in this rule. And it hasn't by giving it a preference over other values and over other evidence. Your Honor, another statutory issue is the failure to address the National Academy of Sciences recommendations. Section 7607D3 requires EPA to consider, or even proposing a rule, the pertinent findings and recommendations of the National Academy of Sciences. Here, there were almost 200 pages of recommendations going to the reliability and accuracy of IRIS assessments, that the NAS published in 2011 and 2014. The EPA made no mention of them in the MON proposal. Both the Supreme Court and this court have noted that 7607 imposes substantive obligations on EPA to consider the NAS's recommendations. Had EPA complied with the statutory requirement, it would have been forced to address many of the same flaws that we're raising today. In fact, EPA has since overhauled the IRIS program in response to those recommendations, but it has not gone back to address the same flaws in the development of the IRIS value for ethylene oxide that it's used in the MON rule. This was contrary to law and renders the MON rule arbitrary and capricious and in violation of the statute. Now, Your Honor, we did address on the factual question of whether the IRIS value is arbitrary and capricious, already the smoker issue. There are a few other examples that I would like to address today. Another issue is the exposure assessments that were used to support the IRIS value. The IRIS value is a dose-response relationship. So relevant to that study is not only the response, how many people are getting lymphoid cancer, the dose, how much ethylene oxide were they exposed to. EPA used the NIOSH study, which did not have exposure data for the vast majority of the time in that study, from 1938 to roughly 76 or 78. So it modeled exposure during that time period. To do this, it assumed there was no change in work practices to reduce ethylene oxide exposure before 1978. That's simply not supported by the record. Petitioners submitted several studies identifying specific work practices that reduced exposure to ethylene oxide over that time. And Your Honor, again, when you talk about studies that were addressed or not addressed, one study they address is Bogan, where they say that one portion of that study was not adequately documented. It does not address the issue of whether there were work practices involved. And in fact, for that, Bogan cites 8 other published studies to identify those work practices, and as well as FDA data demonstrating that medical devices that were subject to sterilization had decreasing levels of ethylene oxide residue on them over time, demonstrating again that those work practices were effective in reducing ethylene oxide exposure. The result is that.
Could I ask you to address the figures over which there was a lot of back and forth in the briefing? And in particular, I think it would make sense to start with figure 4.3 and maybe what is your position about what EPA did with that figure that it shouldn't have done? Because it seemed to me that whenever you said it did something it shouldn't have done, EPA said we didn't do that. So.
Yes, Your Honor. And from a broader perspective, our legal concern is that they did not follow their own guidance with respect to selecting the model to use for the risk value. So once you have the NIOSH data or the study data, the question is, what's the dose response relationship you're finding in that data? Their guidance makes 2 things clear. First, you're supposed to use biology and statistics to identify a model. EPA did not have a biological reason for its model selection. It asserts that ethylene oxide damages DNA. EPA has recognized in the record that this biologically means that the dose response curve should be a line, linear, or curving upward. The model they chose is the exact opposite. It skyrockets and then plateaus.
So this gets to what exactly they mean by linear. And
yes, Your Honor.
It seems, well, their position stated explicitly at the reconsideration stage is that a spline, 2 lines, is what they call a linear model, including their guidelines. And I'm not sure what basis you had to disagree with that.
In the carcinogen guidelines themselves, there is the footnote, though, that says that a spline is a nonlinear model.
Where does it say a spline is nonlinear? It says nonlinear includes, for example, a quadratic model or a threshold model. And in the definition of a low-dose linear model, this case is really fun. It acknowledges that it will not be linear at all values. So it seems like it might not be a layperson's definition of linear, but they've defined linear in a way that would encompass a spline.
Yes, Your Honor. I believe in that footnote 3 that you're citing to, it does reference splines as another example of a nonlinear model. But even if it doesn't, the ultimate issue is that they didn't use this biology as a basis. So biology is off the table. What they've said is they don't have, they're not aware of a mechanistic explanation for the shape of their exposure response curve. So they've abandoned biology. They thought they had statistics to support their model, but there was a problem with their calculation of those statistics, the degrees of freedom. The result is what they thought was a statistically significant model is not statistically significant. In other words, it doesn't predict the data any better than the assumption that there is no relationship between ethylene oxide and lymphoid cancer.
Can I ask you about the biological plausibility?
Yes.
Because it seemed to me repeatedly, they said that other carcinogens do have similar spline-like dose response models on J2393, 1950, other places too. Isn't that the basic type of biological plausibility comparison you're saying they didn't do?
If they were talking about the right carcinogen, it might be, but they're not. And the reason is the mechanism by which something causes cancer. And that's why the issue here is that they've identified ethylene oxide as a direct acting mutagen, which means that it directly mutates DNA. That's not something that would, so the biological process would either be linear, when it contacts DNA, it damages it, or it would be upward curving. There might be some biological defense mechanism, DNA repair, that gets overwhelmed at some point to allow the curve to move upward. The other type of chemical that they've identified, the plateauing effect, is when your body needs to first metabolize the chemical to make it a carcinogen. So in other words, you need a biological mechanism to make it carcinogenic. That can be overwhelmed, and that's how you would get a plateauing effect. But there's nothing in the record and no allegation that ethylene oxide works that way.
Is there anything in the record that says for carcinogens with this direct effect on DNA, they cannot have a spline-like dose response model, which is I think the point you're making.
Yes, in the IRIS assessment itself, it identifies that for the direct acting mutagen, the expectation would be linear or upward curving. And
But
because of that
go
reason,
down to the dispute over what they mean by linear.
well,
Anyway,
not in this
is
context, Your Honor.
This is an important point. So if you have
Yeah.
a cite for that point that you can give us on rebuttal,
yes,
that
Your
would be
Honor.
very helpful.
And then, Your Honor, I see I'm running out of time, but if you'd like to address the interpretation then, with that in mind, of the graph, I'm happy to do that as well.
I think it would be helpful to at least hear the argument.
Okay. So what they did not rely, and the record is clear, they did not rely on biology or statistics to support it. What they did was apply what they call visual fit, which is essentially attempting to eyeball this graph that we're looking at on page 45 of petitioner's brief, and which are referred to as figure 4-3. They tried to say what looks the most like of these straight lines or solid lines, what looks the most like these purple dots. And that has two problems with it. First, the purple dots are not the data. These purple dots are a categorical model that EPA ran. So in other words, they took the 17,000 data points, they identified the 45 or so leukemia mortalities that they wanted to plot. They grouped those into these 5 dots. And then they ran it through, or they grouped them into 5 categories, and then they ran it through a model, a categorical model, to say what's the excess risk. When they sent that to peer review, their science advisory board said, don't do that. Don't use a categorical model to attempt to detect a pattern in the data. When EPA came back, what they did was they used the model, but then used that as their standard for determining what other model, continuous model, would look like the data. And so that's what we mean when we say these dots are not the data. These are just an earlier model EPA ran that was rejected, that they're now trying to find a line that's most similar to. The other problem is.
And so what's wrong with that?
What's wrong with that is that this categorical model is just a model. It doesn't actually
Of
reflect the
course.
pattern in the data.
Of course, it's just the beginning. I mean, you act as though everything is the end. That's only one way to do things. And that's not correct, and you know that.
There are certainly many ways to identify an appropriate model, but what
Yes.
EPA's guidance says is that you're supposed to use the biology and statistics and only deviate from a linear model if, a linear model if biology and statistics support it. And just to start with a linear model and only deviate from that if you have a reason to do so. what the Science Advisory Board specifically said with respect to this is, it is dangerous to use a categorical model to try to find the pattern. You need to use the actual data to identify a pattern. And so the starting point needs to be the data itself. If you run it through a model.
1,000 points.
I'm sorry, Your Honor?
You say you have to use the actual data yourself. Is that correct?
You have to start with the data. Otherwise, what you're finding is not a pattern in the
And
data.
why didn't they start with the data? You don't like where they ended up, but that's a different issue.
Your Honor, we've objected to them not starting with the data, but they have not provided an answer as to why they haven't. I think the answer is inertia. They had a model and they wanted to use it, but they were told not to by the SAB. Rather than go back to the actual data, they simply tried to find a continuous model that would look like the model they'd already run. The problem is the model they originally ran doesn't accurately reflect the data.
So I have a question about, the EPA says in their brief that after the SAB gave this feedback, they actually did go back and
Yes.
run this model using the individual data points. And of course, the categorical dots are based on those individual data points, but that they incorporated that feedback from the SAB and addressed it before finalizing in 2016. Is that just false?
Well, they may have used the individual data to generate these lines, but to select which line they wanted to use, they went back to their categorical model. And that's the problem, because you can generate a whole lot of lines using the individual data. They've got a
But
half
counsel,
dozen right
their
here.
own
Which
answer
one do you
has
use?
acknowledged that they went back to the original data.
To generate
You
models,
know,
but not to
you-
select a model.
I understand, but you have to be careful what you say to the court, because as Judge Garcia said, we're just judges. So you have to be careful what you tell us. And you told us they didn't go back to the original data. Well, they did. And then they went somewhere you don't like, but that's a different issue.
We have raised concerns with the underlying data with respect to the exposure assessment data.
I
With respect to
understand
the
that,
model,
but the question is, to what extent do those objections stand up? And maybe they do, and maybe they don't. But we
Well,
have
and
to understand what the agency did and not be misled. That's all I'm getting at.
yes, Your Honor. And this court has, on several occasions reviewed models. And the question is the model supported by the record evidence? Are the assumptions EPA is making supported by reality?
I understand that, and you disagree with where they come out. But don't mislead us as to how they got there. That's all I'm getting at. We don't need to belabor this.
Yes, Your Honor. And perhaps just to clarify, the reason that the iris value is so off is the selection of the model. So choosing the 1600 knotted spline, that's what drives a lot of the problem with the end result in the iris value. So it was, when you're looking at all these various models, which one do we use? That question was a significant error, selecting a model that isn't supported by a biology or statistics. When they tried to support it with visual fit, our first point is visual fit is not an appropriate way to select a model, period. But if you are going to use visual fit, this particular graph is not one you can use for those two reasons. First, they're trying to fit it to just another model. They're not actually trying to fit it to data. And the second is the chart itself, the figure itself says, don't use me to try to determine which is closer to another, because this is relative risk. This is not the actual risk from the data set.
We'll give you some minutes in reply. Ms. Chen.
Good morning, and may it please the court, Sue Chen for the United States. The court should uphold EPA's use of its cancer risk estimate for ethylene oxide because that estimate is scientifically sound. Now, before I get into my arguments, I'd like to just take a moment to clarify some of the confusion I heard this morning about different parts of EPA's quantification of risk. And just bear in mind, I'm going to throw out a lot of nuances and maybe even oversimplify for the sake of clarity here. So once EPA has concluded, based on the weight of the evidence, that ethylene oxide is a carcinogen, the next task was to quantify that risk. And for that, it used the biggest and most comprehensive human study it had available, and the Science Advisory Board agreed with the choice of that data set. So step one is that EPA took all the 17,000 plus individual data points and used them to create different dose response models. And those are the models you see at JA 2400. It is true that earlier on, EPA had tried to create a dose response model using the categorical data, and that is shown at JA 2401, but the Science Advisory Board said, no, that's not really a good idea. And so EPA went back to the drawing board and looked at the models created with individual data points. So step one was developing different dose response models. Step two is choosing one of those models as the dose response model to use. And this is a step where issues like model fit, categorical breakouts, shape of the dose response relationship come into play. Step three is extrapolation, which petitioners reference in their reply brief. And at this step, EPA takes its dose response model and uses it to calculate a value called the point of departure, which then basically became an input into the extrapolation calculation. And you can see those calculations at JA 2692. And petitioners here don't dispute the methodology for extrapolation. They're really disputing one of the inputs into the extrapolation calculation. Step four, EPA takes the risk calculated from step three and does more statistical analysis and comes up with the cancer risk estimate that we're talking about here. So that at the 50,000 foot level is the different steps EPA took in quantifying risk. Now, I do want to start by addressing the choice of the dose response model and a few things here. The kind of default linear model that petitioners are talking about, that applies to the extrapolation. So that's at step three. And you can see this discussed in the cancer risk guidelines at JA 2129 to 30 and 2224. That is for the extrapolation step. When it comes to finding the dose response model for the observed data, which is what we're talking about at step two, and which is what petitioners are really trying to get at, there is no default linear anything. The guidelines say that a linear model is appropriate unless the fit is poor. But here, and I'm sorry, let me just give you the site for that. This is at JA 2212. Nowhere in the guidelines does it say that for step two, there's a linear model as a default. So I just want to sort of clear the air on that issue. On petitioners claim that all EPA did is sort of eyeball 5 dots to come up with the model. I think that betrays a fundamental misunderstanding of statistical analysis, because categorical breakouts are the common form in statistical analysis to make sense of a big data set, because all you're seeing there is really just a cloud of points. And categorical breakouts allow you to see where the weight of those individual data points fall within an interval and also across different intervals. And that's important because there can be a lot of variation between individuals in how they respond to exposures or other stimuli. And EPA is interested in the average person's response. It's not making decisions based on the atypical response. And the average response is what the categorical breakout allows you to see. I also want to.
Is that breakout drawn from the same 17,000 data points?
Yes, it is. So if you look at JA 2680, table D54, it shows you the interval breakouts. And there are about 3,000 to 4,000 data points within each interval. I also want to push back against petitioners' assertion that somehow the only respectable way to do statistics is to look at numbers and equations. That's just not right. Graphs and other visuals are a critical tool in statistical analysis. I mean, you flip open any statistics textbook and there are graphs all over the place because that kind of visual analysis shows you things that you can't see from just numbers and equations. On whether the models are comparable to each other in terms of relative risk, in figure 4-3, the y-axis tells you that it measures relative risk. And so if you look at the different models, you can see that at a given exposure, one model might tell you that the risk you face is 1.5 times relative to your baseline risk, while another model might tell you it's 2.5 times. So model 2 predicts higher relative risk than model 1 does, and you can absolutely compare the models in terms of relative risk. What they don't tell you is the baseline risk that you face. That depends on who we're talking about in a given analysis. On biological plausibility, I think there's ample support in the record that EPA's analysis is supported by biological realities. First of all, the analysis underwent 2 rounds of external peer review by experts in statistics and epidemiology and toxicology and experts who are well-versed in the relevant literature. And they agreed with EPA's choice of the data set, and they also expressed their preference for the use of a spline model as its dose response model. And this is at JA 3320 to 27. EPA also subjected its analysis to extensive public comments during which commenters submitted a lot of studies, including studies that post-date the cancer risk estimate.
Can I stop you on this, the biological plausibility
Yes.
point? The petitioners say that generally a spline-like model is not, that EPA's own other statements say a spline-like dose response model is not common for this type of carcinogen. What's the response to that?
Well, first of all, they have offered no citations to any authority for that statement, which is a big problem. The other response is, it is true that for mutagenic substances, an increase in exposure means an increase in risk. And that is reflected even in the spline model. When you increase the exposure, the risk increases. Now, there are other factors at play that affect our risk. Some of that might not be completely understood, but we're seeing it in the data. I can give you a couple of theories of why we're seeing this plateauing effect. One is, people who are just more susceptible to a chemical have already gotten sick or died at lower exposures. So the people who stayed on long enough to have these very high cumulative exposures could just be naturally less susceptible to the chemical in the first place. Another theory is that our bodies activate certain defense mechanisms only at high exposures. We don't know exactly why, but that is what we're seeing in the data for not only ethylene oxide, but other occupational carcinogens.
The other question I just wanted to go back to was I want to make sure I'm understanding the dispute over whether this is linear and whether that matters. Because in the reconsideration decision at 4345 to 46, this is where EPA is explaining why it's not going to use the Texas model. And it says the 2-piece linear spline model is a low-dose linear model as defined by the guidelines. And that's why I was asking them questions about the fact that it seems like EPA is saying, this is a linear model that aligns with our guidelines. Are you, but what you said made me worried I'm in the wrong ballpark.
The low dose linear, first of all, the low dose linear is defined as something with a positive slope, which if you look at EPA's model, it has a positive slope.
Yes.
And that the low dose linear discussion applies to extrapolation. So step 3, What we're talking about here with choice of the dose response model is step 2. So we are really in a different ballpark when it comes to what the guideline is saying about low dose linear.
Okay, thank you.
Unless there are other questions about the dose response model, I'd like to move to some of the studies that petitioners.
So could I just ask counsel, all of that is relevant then at step 2?
All of,
What you were just talking about with Judge Garcia? Your low dose linear,
no, the low dose linear as discussed in the guidelines is talking about that as a default for the extrapolation, which is step 3. My point is simply that at step 2, there is no default linear or anything.
thank you.
I just want to say a couple things about the pre-1978 exposure and the smoking studies. On the exposure, the Bogan studies looking at work practices, if you look at the record at JA 4818, which is the Bogan studies, is talking about increased wash cycle since the 1980s, which is after the period we're talking about. So I don't see how that's even relevant here. On the smoker studies, I mean, the problem with the smoker studies is really that absence of evidence is not the same as evidence of absence. And all we have in the smoker studies is really the absence of evidence because they didn't reliably measure ethylene oxide exposure and they didn't quantify the cancer risk. So they don't say anything one way or the other about ethylene oxide's cancer risk, which is what EPA is interested in here.
But I take part of the point to be that the effects of smoking are one of the most studied impacts there is. And if EPA were right about the impact of ethylene oxide, we would at least at a general level expect to see higher cancer rates of this type of cancer in that population if ethylene oxide is causing cancer.
Well, we still have an absence of evidence because the way those studies are pretty vague and non-committal about lymphoid cancer deaths in smokers. I mean, seems like they're saying there are not enough lymphoid cancer deaths out there in smokers. Well, how many are there? And how does that compare with with non-smokers' death rates? We have no idea. There's an absence of information because the studies didn't look at this particular question. I'm happy to address any more questions on the merits. Otherwise, I can turn to the procedural issues.
Go ahead.
Okay. Just a few things on procedural issues. Our brief shows that EPA's use and calculation of the cancer risk estimate is procedurally sound, and I want to just spend a couple minutes on some new arguments raised in the reply about specific National Academy recommendations, which go to things like greater clarity in explaining EPA's methods, better tables to use in comparing different studies, and recommendations to have to create some general protocol and guidance. And although we think the National Academy's recommendations don't even apply here, even if they did, they don't set the standard for arbitrary capricious review. Those recommendations are aspirational goals that are aiming for something higher than just not arbitrary. And so failure to meet some aspirational goals does not translate into arbitrary action as a legal matter. For that, you need to look at what happened here. And what happened here is that EPA reviewed the comments that were submitted, and yes, it disagreed with some of petitioners' comments on the merits, but that is not a reason to find procedural defect.
So do you agree if the NAS had said something like, it's not specific to ethylene oxide, but there are such fundamental problems with this IRIS system that EPA needs to stop until it makes XYZ changes, that would be...
I think that might change the calculus, but the reality is, as EPA explained in its response to comments at JA 1884, the National Academies recognized a lot of improvements that EPA had made, but also that a lot of its recommendations are for the long term, and that there was no need for EPA to just stop all its risk assessments in the meanwhile.
I think it even says affirmatively it shouldn't delay
Mhm.
EPA's risk assessments.
Right. So the National Academies, the way these recommendations are forced, they don't really say anything about what EPA, whether what EPA did was arbitrary capricious. I'm happy to answer any other questions the court may have.
And one last follow-up.
Yeah.
You were starting to talk about biological explanations for a plateauing effect. And I wondered if you had JA citations for those points. Understanding you might not have them at the tip of your.
Yes, it's at JA 2617.
Thank you.
All right.
Thank you very much.
Why don't you take 2 minutes?
Your Honor, Judge Garcia, one of your questions was for the cite in the record to the biological mechanism, and that's at JA 2476. That's in the IRIS assessment. With respect to the NAS recommendation, we've heard some discussion about the long-term recommendations. There are a number of recommendations in there that would have addressed this issue, including the requirement that EPA better consider biology, better elucidate the selection of studies, better rely on statistics. The fact that they may be long-term and not addressed in every IRIS value is not a reason not to comply with 7607D3, which required EPA to identify and consider those recommendations. They don't have to comply with all of them before proceeding with rulemaking, but they have to show that they have considered them and their relevance to the rulemaking before they proceed. That's the violation we've identified here. We did not hear any response on the preference for IRIS. Fact is that poisoned the entire rulemaking. If EPA was not going to consider everything on the way to the evidence, like they told Congress they would do, and what Congress incorporated through the Benzene NESHAP, they have not conducted a rulemaking as they were required to do by law. We heard a reference that we do not dispute the method of extrapolation. We absolutely do. That is their model selection. There is no data at the concentrations EPA is attempting to regulate. All of this is an exercise in extrapolation. And the way they're extrapolating is by trying to rely on a model that does not have a statistical basis. They've described the graphs as a physical tool or as a critical tool, but they cite nothing for that. There is no guidance that says visual fit should be a primary basis for selecting a model. The most that's in their guidance is that it can be a confirmatory basis of a model driven by biology and statistics. We continue to have a dispute over the y-axis. Most of their brief and an argument you've heard that you can compare them to see how close they are. The footnote speaks for itself, however. It says that the graphs are not strictly comparable across the y-axis. And that's because what they're showing here is rates of increase, not absolute increases. They've emphasized, we've heard today that they emphasize that this selection has undergone peer review. It's worth clarifying that this model selection did not go through peer review. This model selection was done after the last peer review by the SAB. In addition, on the issue of smokers, we heard that there is perhaps not enough smokers to elucidate the data effect we're identifying. That's unsupported by the record. There are more than enough smokers in this country to identify if the IRIS value were correct, that there would be a link to lymphoid cancer. Your Honors, because EPA did not follow its own guidance, disregarded the National Academy of Sciences recommendations, replaced the required statistical and biological analysis with eyeballing a chart, this was not a rational basis for rules with major real-world ramifications. Particularly since the results fail multiple reality checks, we request that the rule be vacated and the case remanded to EPA for a new risk assessment.
Right, I believe Judge Garcia wanted a cite.
He gave it to me.
Oh, okay.
Thank you.
Okay, right, thank you.
Case number 23-5004, Assassination Archives and Research Center, appellants versus United States Department of Justice. Mr. McClanahan for the appellant, Ms. Johnson for the appellate.
Mr. McClanahan, good morning.
I heard someone say my name, but I couldn't tell who it was. Oh, okay. Hi.
That's me. Good
Oh, okay.
morning.
Sorry about that. I didn't see your lips move, and so there was a little confusion. Good morning, Your Honors. Kel McClanahan for the AARC in this case. I think that this case is best understood by first addressing what it's not about and what decisions the district court did not make that we're saying they should have made. The district court did not make any of the following calls on the merits: that AARC was not entitled to a fee waiver, that the FBI assessed reasonable fees, that an Open America motion was not required, that the FBI conducted an adequate search for the requests in counts 2 and 3, that the FBI properly withheld material from any count, or that count 1 was partially not a reasonable request because it was unduly burdensome. This was the evidence the FBI did not offer: that it conducted any adequate searches, that it made any proper withholdings, or that any part of count 1 was an improper request. These are the decisions that the district court did make that were challenging. First, that a heart attack, a COVID shutdown, and the birth of my now youngest child were not good cause for extensions. That needing to research arguments and write a brief and consult with other experts was good cause for the DOJ lawyers' extensions. That needing supervisory approval for briefs was good cause for the DOJ lawyers' extensions. That not paying $52.50 of disputed fees warranted the full dismissal of a case, and that filing a reply late is grounds for dismissal of the underlying motions, despite the fact that there were 4 briefs on the record. That's what we're talking about. This is a case that should have been fairly straightforward. It should have been a case where the FBI filed their motion that showed that they had properly denied a fee waiver, filed a motion showing that they were properly assessing fees. We would have opposed it. Whether or not we would have won, that's up to the district court. That's up to this court.
I have a question about
Certainly.
what's really before us now, because the end of that road, as you said, which is what we're reviewing on appeal, is a Rule 41B dismissal on the grounds of failure to comply with the court order. And so if we were persuaded there's not an abuse of discretion at that point in dismissing the case for non-compliance with a court order, why would it matter if there were errors earlier in the case on the way to that result?
Your Honor, I don't think that that is the only thing before you. I think that everything that we have challenged that were decisions on the merits, and I'm setting that apart from things like the fee waiver denial and the Open America ruling that weren't really decided on the merits, but the procedural things you're talking about, each one of them led inexorably towards the end of the case. That If the FBI had been required to go first, like FOIA case law dictates it should, then I would not have needed to go first. I would not have needed to, try to mine the president of AARC for information about what he thought the FBI might have been thinking of when it made its decision in the absence of a record. If the extension had,
Go ahead.
yes, ma'am.
No, excuse me.
Oh, sorry. If the district court had,
Typically, I just
Oh.
want to, and I just want to understand why this isn't the right way to think about this, that you might have had good grounds to disagree with a lot of things that happened earlier in the case. But when you receive a court order that you disagree with, you still have to comply with it, preserve your rights to appeal and all of that sort of thing. One thing you can't do under Rule 41B is just disregard it. And as I understand it, that's what the district court thought had occurred here when the fees weren't paid in February and then again in September. And then we get the government's motion to dismiss and there's not a response to that, it's hard for me to see how we could then conclude that the dismissal was an abuse of discretion.
if you accept the premise that you're setting forth, that it was a court order to pay the fees, that could lead to the conclusion you're talking about, that an unwillingness to pay the fees would trigger a violation of an order. That's not how we see it, though. We see it as the judge could not have assessed the fees, could not have told us to pay the fees without first saying that they were properly assessed. And that by ordering us to pay fees, and more importantly, by dismissing the case for failure to pay fees without first finding that the fees were proper, that was reversible error. And on the bigger point, that even if it was worthy of a sanction, even if it was worthy of something for you violated my order, you did not pay the fees, the proportionality comes into question, where every step of the way, everything that we're appealing here, well, not everything that we're appealing, but the latter few steps that we're appealing here, were all grossly disproportionate to the misconduct that we were being alleged to have done. Where, I filed a motion to file a reply brief late. It violated the court's standing order. I understood that. I could have properly been sanctioned for that. They would, a proper sanction for that would have been something like, I will not accept the reply brief. The proper sanction is not, I will therefore dismiss the two cases, or the two motions that have already had an initial brief and an oppo brief. And from that point forward, everything that happened was a sledgehammer of a sanction to a small procedural misconduct, even if we accept that everything I did was wrong.
Well, what about the perspective of the district court judge in terms of this was a matter that had been going on for some time and it was back and forth? Then there was a period when the FBI started turning things over. You started paying fees. The FBI turned over some more documents, you paid fees, and it went back and forth for a while until, and tell me if I'm wrong, that there was $53 or $53 left. And there were some more pages to be turned over to you. And the judge issued several orders and there was no response. And he dismissed the case. And from the, tell me if I'm wrong, from the district court's point of view, you were on notice that the case would be dismissed if you didn't pay the fees. and nothing was filed before the court. In other words, you more or less had ignored the judge at that point.
That is not correct, Your Honor. I see where you could have drawn that conclusion, but that's not actually how it played out.
Okay,
The warning that you're talking about, and first of all, to go back to, there was only $52.50 left. There were still about 36 months worth of records that had yet to be turned over. And so this was not an argument over I've paid everything but $52.50. This was an argument over we stopped paying monthly fees every time the FBI sent us records because we were challenging the propriety of the fees. We were filing these motions. So that's the first part, that there was still the prospect of hundreds of dollars of fees in our future. The second thing, though, is that regarding that we were on notice that it would be dismissed if we didn't pay the fees. That's not entirely accurate. What we were on notice of and what the judge did basically invite the DOJ and the FBI to do is, if we did not pay the fees, brief why not paying the fees was not ground to stop the processing, which would have stopped the processing of that request in count one and led to summary judgment briefing about the searches, about the withholdings from the records they've already done, about the propriety of the request. All of that stuff would have happened after the FBI briefed the issue of they stopped paying fees, so we should be allowed to stop producing records. They
so
didn't.
let's just be clear. You were never under notice that the cases were subject to being dismissed?
Not until the very end. That the final round of briefing came out of the blue, where the judge, after he ruled, because the motion the FBI filed was they have not paid the fees, we should be allowed to stop producing records. That was what we expected would happen. They filed this motion. I opposed it, and when I opposed it, that's when I said they can't charge these fees because it was not reasonably the reasonable fees. They did not grant our fee waiver, et cetera, et cetera. The judge dismissed that, overruled my challenges, granted the FBI's motion, saying, okay, now brief whether or not this needs to be dismissed in its entirety. That came from nowhere.
So you had an opportunity to file a pleading in response to your information about pending dismissal.
We did, and we did not file anything. I do concede, we did not file the final brief against dismissal because based on the judge's previous holdings and how our previous briefs had been ignored, there was nothing we could argue on. When the judge said, file a motion to dismiss based on, in its entirety, based on refusal to do this, there was nothing we could contest because we did not pay the fees because we were still contesting that the fees were proper in the first place. And we ran the risk of it being denied, but that was the only way to get any of this reversed and to get it before you.
All right, your time is up.
All right.
Ms. Johnson? Morning.
May it please the court. Good morning, your honors. My name is Stephanie Johnson. I'm here on behalf of the government. Absent a fee waiver, ARC was required to pay the fees, pay the reasonable duplication fees under FOIA. The district court properly granted partial summary judgment and ordered ARC to pay the outstanding balance by a date certain. ARC chose and failed to pay the outstanding balance, and the court, within its discretion, dismissed this case with prejudice under Rule 41B, and it was unopposed by ARC. So we would.
Our court, as you know, I'm sure, has precedent talking about all other options about sanction are supposed to be exhausted before a case is dismissed. Are you familiar with that case law?
Yes, Your Honor, and I'm also familiar with this circuit also saying that the court does not have to choose the less severe option. And in this particular case,
Well, that's not what's been on the books of this circuit for years. Okay, so maybe that is one case. But I just want to be clear. Did you think that other options had been exhausted by the district court?
I think in this case, the court put plaintiff or ARC on notice multiple times, warned ARC multiple times that it had violated previous orders, and that if they continue to violate orders, I mean, I guess it's reasonable to assume that there would be consequences. In this
Yes,
particular,
but our court, with this one exception you cited to me now, and you can give me the cite to it. Other options are supposed to be exhausted before a case is dismissed.
Your Honor, in this particular case, the court ordered ARC to pay the outstanding balance. ARC did not pay that outstanding balance. The court then again ordered ARC to pay the outstanding balance and warned ARC in the order that the case could potentially be dismissed. ARC chose not to respond to the government's motion to dismiss, even though we requested in our motion to dismiss that the case be dismissed with prejudice. And it's also presumed under 41B, if the court does decide to dismiss the case under 41B, that it could be dismissed with prejudice. ARC chose not to put in a response or any opposition to our motion to dismiss. And so without opposition, the court in the government's opinion, did properly dismiss this case absent any opposition from ARC. So the court did give ARC an opportunity to pay the outstanding balance at least twice, and they chose not to pay, and they also chose not to oppose our motion to dismiss. So in order to move the case along, the only option left for the court is to dismiss the case. If the court has no further questions for the government, we would request that the court affirm the decision below. Thank you.
Does council have anything left? All right. Judge Garcia, do you have any questions?
No.
Right. Judge Rogers, do you have any questions? All right, your case is submitted.
This honorable court is now adjourned until Tuesday, February 20th at 9:30 p.m.